Happy New Year. So how do I see it here? So are we live now? Okay, can you help me still? Good afternoon, ladies and gentlemen. Happy New Year 2025. Welcome to a brand new year. We pray that this year will be a successful year for all of our listeners worldwide. Thank you for joining us again. Remember to invite your family, friends, and colleagues at work so that you join us. We are expecting a brand new administration. However, before the new administration come into office, we intend to deal with a couple of things. Today, we'll be dealing with general immigration questions and answers. We have some unanswered questions that has been previously raised. Please start sending questions that we have received. So we have some unanswered questions, so we want to make sure that we deal with that before the new administration come into play. We also have a brand new topic that we'll be discussing next week by God's grace. And thereafter, we hope to wait for the new administration and see the direction we'll be going, and we will flow in that direction. Right now, it will be premature to start discussing what the new administration will do or what they will not do. At this stage, we are still at the speculation stage. But for now, we are going to continue with general questions and answers. And next week, by God's grace, we'll be dealing with a topic called International Entrepreneurial Rule. International Entrepreneurial Rule. That will be the topic for next week. But for today, we'll be having question and answers because we want to clear all the existing questions before we go into brand new year and brand new administration. So if you have questions, send your questions in. Again, our numbers are 817-883-4495. 817-883-4495. Another one is 817-983-4499. 817-983-4499. Another one is 817-891-6655. 817-891-6655. So, if you have a general immigration questions, this is an opportunity for you to ask because today we are discussing general immigration questions and answers, and we are willing to accommodate any question on any topic, on any immigration topic. That is what we'll be doing today. So we are waiting for your questions. Start sending them in, and we will deal with it. As I said, we all know that probably within the next, how many days now? Probably 12 days. The new administration will come in. So we will be dealing with it at that time. But right now, everything remains at the speculation stage. And as professionals, we are not in the business of speculation. So we are going to wait and see what action or inaction the new government will take. And then we flow from whatever direction the tide is. But today, we are discussing general immigration questions and answers. So if you have questions, please send them in. Please send them in if we have questions. Okay. If you have more than one, I can read out the first one. So while I answer it, then you transfer the other ones. So if you have questions, send them in. Send your questions in. Today is an opportunity. those who normally send questions or ask questions that are unrelated to the topic of the day, today is your opportunity to ask any question on immigration. It's a general immigration question and answers. This is because we want to clear all the existing questions before we go into the new administration. And by next week, by God's grace, we will be dealing with a topic called International Entrepreneur Rule. That is the topic we'll be dealing with next week. Let me write it down so that I don't forget now that it's coming to my head. International Entrepreneur Rule. That is the topic we will be discussing next week. But for today, we'll be answering general immigration questions and answers. Okay, I think we started having questions. The first question I received today is, I was ordered removed in absentia and I found out about 3 years ago. I'm now married to a U.S. citizen. Can he file for me? Well, whether you are ordered removed or not, that has nothing to do with the filing. At any point, whether you are in the United States or not, a U.S. citizen can always submit a petition on behalf of his or her spouse. However, in this particular case, if you have been ordered removed, if immigration invites you for interview for the adjudication of the I-130 petition, I can assure you with 100% certainty that you are going to be arrested during the interview and detained and or removed from the United States. So in order to prevent that, what you can do, if you have an attorney, contact your attorney. Your attorney will know what to do. But if you don't have an attorney, I will advise you contact an experienced immigration attorney. The attorney will need to file a motion to reopen in your case and have the case reopened before you appear for an interview. In fact, I have a similar case recently. My client was ordered removed in absentia. Unfortunately, she didn't know about it because she didn't even receive the hearing notice. Subsequently, she married a U.S. citizen. They came here, we filed the I-130 petition. Then they were invited for interview. But because of our experience, normally, whenever somebody who is undocumented, somebody who is out of status, whenever we file I-130, before I take them to immigration office, I always check the EOIR to find out if they have any form of removal order or if they are in any form of danger. This is based on experience. I remember probably maybe around 2004, 2005, I had a client then who was detained at immigration during an interview. Of course, I was not representing this person at the time. It was only after the spouse was detained at the immigration that they retained me. But that experience always rings in my head because that woman was detained for more than 6 months before I was able to get her out of detention. And I did a lot of things to ensure that she was not removed before that time. I mean, I did a lot of things that I cannot even legally state here. I went out of my way to ensure that that person was not removed from the United States. But we thank God for the success of that story. But the point here is, if you have a removal order and you are invited for interview, it's like going into a lion's den. There is no way you are going to come out without being detained. So in order to avoid it, you have to get that removal order reopened. You have to file a motion to reopen and have your case reopened. So even if a decision has not been entered, once you file a motion to reopen and you file a motion for stay of proceedings, then you can safely go for your interview. In the case of the client I was talking about, of course, it was when we received the invitation letter, interview letter, that I decided to check to see if she was in any form of danger. This was probably 3 or 4 days before the interview days. Then I realized that she has been ordered removed. She didn't even know herself. So again, what did I do? The first thing I did was to contact immigration and request them to reschedule the interview, that the petitioner, who is the US citizen, was unavailable, and as the attorney, I was also not available because of a conflict, a prior scheduled appointment. So we requested the interview to be rescheduled, which of course USCIS did. That gave us time to file a motion to reopen, go back to the court, and have the motion reopened. It is only after that that you can take somebody to interview and that person will not be at risk of being arrested. So that is the first answer to the first question. So yes, your US citizen spouse can file a petition for you, but if you are invited for interview and without reopening this case, if you go there, you know that the court orders have to be enforced. So ICE will be there waiting for you, and as soon as you go into the office, you will be arrested if that case is not reopened. So the next question: what can I expect during my interview based on marriage if I was married before to the same person? Is it okay to remarry? I'm not sure I understand this question.
Looks like the person,
The second,
yeah, it looks like the person remarried the prior husband.
okay, what can I expect during my interview based on marriage if I was married before to the same person? Is it okay to remarry? Okay, my understanding of this question, I'm not sure if I'm right or wrong, but if whoever sent this question, if you are listening, you may want to send a follow-up, but I will answer it based on my understanding of the question. My understanding of the question is that this person was married to A, divorced A, married B, through B, got citizenship, divorced B, and now want to go back to marry A. That is my understanding of the question. So you are married to somebody before, you divorced, you married somebody else, you became a US citizen, and then you divorce again, you remarry your first or prior spouse. If that is the case, so what is the question? Is it okay to remarry? Well, what I will tell you is that
I think it's what to expect at the interview.
I saw something like, is it okay to remarry? Okay, what can I expect during my interview based on marriage if I was married before to the same person? Is it okay to remarry? You see, there are two questions in one. Okay, you see, this is a question that the answer is not a yes or no answer. This is not a kind of yes or no answer. There are so many variables. The simple answer is that there is no law that prevents somebody from remarrying a prior spouse. No such law. And I can tell you, I have represented hundreds of people in that situation. That is not an issue. However, I always advise my client, before you go back to remarry your prior spouse, you have to ensure that you put your house in order. You have to ensure that you put your house in order. Immigration law is not static. It is something that changes from time to time. And I can tell you, during Donald Trump's first administration, between 2016 and 2017 and 2020, there were so many changes to the enforcement. The law did not change. There were so many changes to the enforcement of immigration law. And these changes involve verification of documents. So between 2017 and now, those who submit foreign divorce documents to immigration, many of the divorce documents are being verified. So, if you obtain your own citizenship at a time that they were not verifying those documents, or if you manage to escape it without being verified, if that document is not genuine, or if that document has a question mark, if you remarry your spouse, remember, it does not matter whether it is the previous spouse or not. Every marriage that you have entered into, you have to submit divorce document. You have to submit evidence of termination of all prior marriages. So you are going to be in a position where you will now have to resubmit that document. So if you have a problem with that document, not only can the interview go wrong, it can even affect you. I always tell people, as at today, under the US immigration law, the only time a citizenship can be revoked is when immigration can prove with documentary evidence, when they can prove that the citizenship was obtained by fraud. That is the only time that citizenship can be revoked. If a US citizen today, a naturalized citizen, even if the person committed murder, which I consider probably the greatest offense anybody can commit, they cannot revoke citizenship based on that. If a naturalized citizen is a terrorist and committed terrorist activities, which is a very serious crime, again, they cannot revoke citizenship because of that. Whatever they do to people who commit crime, that is what they will do to the person. But the only time that citizenship can be revoked is if immigration can prove that this citizenship was obtained by fraud. That is the only time. So, what am I saying here? If you don't put your house in order and you remarry your prior spouse, and you now put yourself in a position where you have to submit a divorce document that was not legit, which you managed to escape, now if they verify it and realize that this document is problematic, not only is the I-130 going to be denied, but you yourself as a US citizen, you will be at risk of getting your own citizenship revoked. Again, this is not limited to your prior spouse. It doesn't matter whether you marry your prior spouse or not. If you marry and file a petition for anybody at all, both the petitioner and the beneficiary, both of them must submit evidence of termination of all prior marriages. So, if you know that your document is questionable and by grace you manage to escape it, my brother, my sister, I don't know who sent this question, I will avoid any contact with immigration that will require me to resubmit those documents. So a word is enough for the wise. I won't say more than that on this question. The next question. I have been issued a request for evidence on my adjustment of status to file a waiver for misrepresentation. Do I respond to the request with the completed form? No, you cannot. You have to file the waiver separately, get the receipt, and then respond to the request for evidence with the receipt notice showing that you have filed the waiver. Once you do that, the officer will be in a position to pull up the waiver application and adjudicate it together with the petition that you have filed. So the next question. Now that the new administration is coming, will public charge become an issue again? I said at the beginning of this podcast that everything about the new administration right now is we are at the speculation stage. I cannot tell you anything that is authoritative at this time because we are at the speculation stage. However, looking at antecedent, I suspect, yes, they probably will bring up a lot of things. If you recollect, if you are here during Donald Trump's first administration, he introduced a lot of things, including Form I-944. That is Declaration of Self-Sufficiency. And I remember in that application at the time, every applicant, you have to submit your credit report, you have to submit your credential from your home country.
Remember they added another form, I-915, I think it was.
Yeah, so there are a lot of things that were introduced. Of course, you have to show how you have been maintaining yourself, what you have been doing since you entered the United States. I mean, what you are doing in your home country, what education you have, what it was a lot. It was a lot. But when Biden administration came, he reversed all those things. And I can almost guarantee you that they probably will bring a lot of things back. Again, we don't know for sure, but based on antecedent, America is good at something. They look at somebody's antecedent to project what the person can do in the future. So looking at his antecedent, I can assure you, is probably going to introduce all those things back, because those are some of the things that scared people from filing at the time. Because even through credit report, they can see your address. They can see a lot of things that is not even immigration related. They can see the level of loan that you have. I mean, these things are not immigration related. But during Donald Trump administration, he was asking for all information about everybody, even including social media handles and all those things. You have to provide all those information. Again, we are probably going to witness the same thing. But right now, this is not authoritative. We are just speculating. But based on its antecedent, I will not be surprised if those things come back again. The next question. I have been asked several times to help as a co-sponsor for different people, but I need to know my obligations, and I like to know if it can affect me at all. This is a very, very, very good question, and I thank whoever sent this question. Let me say this, without scaring you, affidavit of support is actually a contract between the sponsor and the U.S. government. This is one of the laws in this country that have been dormant. Dormant in that the government have not been enforcing it. But it is not impossible that Donald Trump administration will enforce it. It is a contract between a sponsor and the U.S. government, and the sponsor is assuring the government that this person will not be a liability. This person will not be a public charge. So, if it turns out that this person applied for benefit, the government can file a lawsuit. And I've actually seen this happen before. Even though, like I said, this law is not something that the government really pay attention to. It's not something that the government enforce all the time. But I've seen them enforce it before. The government can go after you and sue you for the recovery of whatever benefit this person gets. Yes, so you are making a commitment to the government when you sign an affidavit of support. You are making a commitment to the U.S. government that you are assuring them that this person will not become a liability to the government. So until that person becomes a U.S. citizen, your obligation remains until that time. So if this person becomes a permanent resident, decide to apply for food stamp, decide to apply for benefit, decide to apply for SNAP or any other government benefit, if the government choose to enforce the affidavit of support, they can go after you to recover the cost of all those things, including their attorney's fees. And like I said, I've seen the government do this before. It's just that it is very rare. They usually don't do it. But I won't rule it out during Donald Trump administration. So every person that you co-sign for, you are assuring the U.S. government that those people will not become a liability to the government. So it is a contract that you are signing, and it is enforceable by the government. It's a unilateral contract. Unfortunately, you are not going to be able to enforce it because there is no obligation on the part of the government for you to enforce anything against them. But it's a unilateral contract that the government can enforce against you. The next question. I contacted USCIS yesterday about my marriage-based adjustment of status application, which has been pending since 2021, November 30th. I requested to escalate to Tier 2 officer. Is there a continuation?
Yes.
Oh, okay. Yeah, I've seen the continuation. The reason I gave was inability to get a credible job because I don't have permanent residency or citizenship. Secondly, the case is outside normal processing time. My question is, do you think I have a chance, and what can I expect when a Tier 2 officer calls me? Well, the inability to get a credible job is not a ground for escalation when adjustment of status application is pending. That is not a ground for escalation, especially if you have employment authorization. The reason they give employment authorization is because they know that the application for permanent resident can be delayed. However, let me explain this. Number one, application for permanent resident is not an application that is of right. It is a discretionary application. Unfortunately, this is something that a lot of people don't know. A lot of people think that it is of right. No, it is not. Even the U.S. citizen cannot do anything about it. The lawyer cannot do anything about it. This is a discretionary application. And again, application for permanent resident, I-485, it is an application that requires extended background check. Sometimes, depending on what they uncover in the background check, cases may delay for several years. Application for permanent resident, I-485, is not one of those applications where you can file mandamus. I want you to understand these things very clearly, because I know that some people may be thinking, oh, this thing has been pending for 4 years. Oh, go and file mandamus. No. Application for permanent resident is not one of those situations. You cannot file mandamus because it is a discretionary application, and it is an application that requires extended background check. So the only thing you can do is to do a service request, which is what you have done. So the Tier 2 officer, if they call you back, they probably will just explain to you that your application is still pending. Unfortunately, this is not one of those cases where you can file a mandamus or where you can do anything extraordinary, because it is a discretionary application. Every application that is discretionary, the court does not interfere. The court have ruled in the past that in a discretionary application, a court cannot tell USCIS to use their discretion one way or the other. If they are able to do that, then they will defeat the purpose of the Congress who made the application a discretionary one. So for the court to intervene, it will require a change in the law. So you are at the mercy of immigration in this type of application. So the only thing you can do is to keep on putting pressure. Or maybe you contact your congressman or your local senator. They can use their liaison office to contact immigration. Sometimes it works, sometimes it doesn't work. You can also request ombudsman intervention. Again, sometimes it works, sometimes it doesn't work. But there is really nothing you can do about it because it is a discretionary application, and it is an application that requires extended background check. Again, let me tell you, one of the things that usually delay application for permanent resident, if you have filed multiple applications with immigration in the past, application for permanent resident is one application that cannot be approved until all your files are matched. Because the presumption is that if you have a different file in a different office, there may be something in that file that disqualifies you from getting your application approved. So they cannot adjudicate it until all of the files are combined together. Again, they cannot adjudicate it until the result of the extended background check comes to play. And that is why it is something that you really cannot do anything about. Let me tell you, for you to, whoever sent this question, okay, I saw the name, but I'm not going to mention it publicly. For you to understand the gravity of the power of immigration when it comes to I-485, application for permanent resident, I want to tell you that I have a client whose application for permanent resident has been pending since 2005. 2005. This is 2024. It has been pending for 19 years. And it has not been denied, and it has not been approved for 19 years. We have done everything humanly possible. Like I said, this is not one of those cases where you can file a mandamus. And what we found out in that particular case, in the course of extended background, USCIS is claiming that there is a link between that client and terrorism in his home country. And unfortunately, they claim that he was a member of a particular organization, and that organization has been designated by the US government as a terrorist organization. So, I mean, again, there's nothing we can do. It's a discretionary application. You can't challenge it in court. You can't do anything. So we have just been putting pressure upon pressure upon pressure. But to date, as I'm speaking to you today, that application is still pending since 2005. So that is just for you to understand the gravity of the discretionary authority that USCIS have over I-485 application. So let me go to the next question. I think there was a question I escaped because I was reading the second and third part of this question. I don't see the question anymore. Did it disappear?
I think you removed it.
Oh, you removed the question?
Mm-hmm.
Oh, okay. Do you know where I am in the...
It was right after the very first one that he retracted.
Yeah, because he removed it, I can't identify which one is next.
It's the next one. You see his name here? His name is the one right next.
That's not what is showing on my own phone.
Oh, okay. So it's the one that says, I have applied for humanitarian parole.
Okay, hold on. Maybe the person was afraid that I was going to mention his name, but I didn't.
No, his name is there. I think he realized that he was asking for mandamus when it was actually about ombudsman request.
Oh, okay.
Yes.
No, you cannot file a mandamus in this type of case. What did you say was the next question?
I have applied for humanitarian parole.
I can't see that here.
That's after the question of the co-sponsor.
Okay, I've seen it now. Thank you. So the next question here is that I have applied for humanitarian parole, but I haven't received a receipt notice, and I have heard that USCIS does not issue receipt notice. How can I know the case is pending? Well, humanitarian parole is one of those discretionary applications, and unfortunately, USCIS usually does not issue receipt notice for it. However, I believe sometimes they send applicants for biometrics. So if you receive biometric notice, that will be the only evidence that you have to show that the case is pending. But if you have not received biometric notice, then there is nothing that you can have as evidence that it is pending. As lawyers, the only way we know that it is pending is because we don't mail anything to immigration with regular mailing. So we always have a trackable delivery method. So at least we are sure that it was delivered to immigration, and then we wait whether the client will be scheduled for biometrics or not. If you are scheduled for biometrics, that biometrics letter will give you a receipt number, or in some cases, will give you some form of identification that you can use to show that you have something pending. Other than that, you are not going to get anything until the case is adjudicated and you get either an approval notice or a denial notice. Okay, the next question. What are the best practice to prepare for an unexpected visit from immigration enforcement? Well, what I will say in this question is that if you are not documented, if you are not legal, you have to be mindful of your actions. When I say mindful of your actions, is that from experience, even during Donald Trump's administration, the last administration, or any other administration since I've been doing this job, the risky thing, the most risky thing is for anybody to do anything that will call the attention of law enforcement. It doesn't matter whether it is local law enforcement or immigration law enforcement. Don't do anything that will require the attention of law enforcement. Don't get yourself involved in anything. And when I say anything, it varies. I remember a long time ago, I have a client who was interviewed for citizenship, and he passed the citizenship interview. They scheduled him for swearing in. He was so happy. The swearing in, I think, was a night before the swearing in. I don't know what she did. He did. He had some drinks and all of that, and then drove his vehicle into a gas station, parked inside the gas station, and slept off right there. Now, the people working at the gas station, they saw a vehicle parked, they saw somebody in the vehicle, they were expecting the person to come out, he didn't come out. After some time, they decided to call the cops. So the cops came, knocked on the vehicle, and realized that the man was drunk. Long story short, from that simple interaction, this person missed the opportunity to become a US citizen. From that simple interaction, because he was drunk. So he was eventually charged for maybe public intoxication or something. They didn't charge him with DWI because he wasn't driving, but they still charge him for getting drunk, public intoxication. And that affected his ability to become a US citizen. I've seen another situation where a client, or maybe the daughter of a client, again, we apply for citizenship. The application has already been approved. This person followed a friend. I mean, they were in college, followed a friend to a place. That friend, not her, that friend stole something. They invited the police. Of course, both of them were arrested. So when it was the day of the swearing in, when they ran the fingerprint, they saw a police arrest. They suspended the swearing in. That incident, it took us several years after that incident before she was able to become a US citizen. There are other situations where somebody will just be stopped by the cops on the road, maybe for speeding. Little things that can attract the attention of police officers. Again, it doesn't matter whether it is the local police, state police, federal police, ICE police, it does not matter. The most important thing is avoid anything that will create attention to law enforcement agents. That is the first thing. Secondly, if you are in your house and you are undocumented, one of the first things I will ask you to do is to get, I don't want to market for these people, but get a camera on your door. Put a camera on your door so that when somebody pushes the bell, look through the camera to see who is outside. Remember, immigration officers, they come in mufti too. Sometimes they come with uniform, ICE officers in particular. Sometimes they come in uniform and sometimes they come with ordinary mufti. It is only when they see you that they will bring out their ID to identify themselves. But if you are undocumented and strangers, complete strangers, knock on your door and push your bell, look through the camera to see who is there. If there are people you don't know, don't open your door. The thing is, immigration is not a criminal matter. They cannot force your door open. They cannot force it. Because for them to do that, they will need a warrant of arrest. And of course, because immigration is not a criminal matter, it is not something that they can take to a judge. Judge, sign this warrant of arrest. They will ask them if you have committed a crime. So it is not a criminal matter. So they cannot force your door open. But if they knock on your door and you open it, then they have a right to come in. But even then, you may choose not to open your door for them. The best thing, put a camera at your door so that at any point in time, you will see whoever is at your door. I've seen clients. I remember there was a client who, during Donald Trump's first administration, she was on the phone with a friend. The friend was supposed to visit her, and they were talking on the phone. So after some time, somebody pushed the bell. This client thought that it was the friend who was coming, and she just went ahead and opened the door. Guess what? They were ICE officers. So don't assume. Don't jump to the door if you know you are undocumented. Put a camera at your door so that once you hear a bell or a knock, the first thing, look at the camera. Who is there? If it's a face you don't know or it's not somebody you are expecting, don't open the door. Don't open the door. That would be my suggestion to that question.
In regards to that question, a lot of officers will start maybe lying about the consequences of not opening the door.
That is if they know you are inside. It's not as if you are going to talk.
But if they do know that you're inside and you just refuse to open the door,
How are they going to know that?
well, let's say you ask.
No, just stay inside. Don't say anything. Go to your camera, look at who is at the door. If it is not a familiar face, just stay back. Don't say a word. Don't ask who is there. What do you want? Because the moment you say that, they know you are inside. So even if they cannot force the door, they can decide to hang around because you are not going to stay indoor forever. I've seen that happen before, where they will hang around. You will think they have left, and they will just hang around waiting for you to get out of the of the house or maybe apartment or go into your car. I've seen that happen. So they will even go to your car before you get there. They will run the license plate to determine which of the vehicles in the apartment is yours or which of the vehicles at the house is yours. Remember, these are federal government officials. They have access to a lot of things. They could look at your license plate and run it and know who owns the vehicle. So there's a lot of things that they can know. So if they see a vehicle parked in front of your apartment or in front of your home and they ran it and they confirm that this is your vehicle and they press the bell, you don't open, they can decide to stay around. But for as long as you don't say anything, just look at your camera, see who is there. If it is not a familiar face, just stay in your room or in your house, wherever you are. Don't say a word, just stay in there until whenever they leave. And if they are taking time and they are not leaving, if you have a lawyer, call your lawyer immediately so that at least something can be arranged. But if for any reason you open the door or they get to you, one thing I will advise you, don't play hard game. Officers don't like it. It affects ability to get bond. It affects ability to be bailed out. Once they get you, if they ask for your passport, just hand it over. No argument. If they ask for anything, just cooperate. But if they don't get you, if they knock on your door, don't open the door. So the next question.
I think it's, I'm married to a US citizen. I'm currently in Nigeria. No, Nigeria.
Okay, yeah, I got the next question.
What are my rights?
Okay. I am married to a US citizen and I'm currently in Nigeria. I was called for an interview and they kept my passport and divorce decree. It has been 1 year and no updates. I have sent several requests of status to the embassy, but no response. How can I retrieve my document? Well, the issue here is that if you request for your document, that will mean that you don't want them to continue with the processing. So the best thing is to be a little patient. It may be that they decided to investigate the divorce decree. I mean, whoever sent this question, if you have been listening since the beginning of this podcast, one of the things I mentioned was that during Donald Trump administration between 2017 and 2020, they increased the verification of documents. So it may be that they have issues with the divorce decree and they decided to investigate it. And if they investigate it and realize that something is wrong, because this is an immigrant petition, the embassy does not have the authority to deny an immigrant petition. So they will probably contact USCIS and notify USCIS of what the problem is. And again, because it's an immigrant petition, it depends on the gravity of their findings. If the gravity of their findings goes to the root of the petition, then they are going to send it back to USCIS with a recommendation for revocation of the approved I-130 petition. But because this is something that affects the right of a US citizen, it is not a recommendation that they just make without a detailed investigation. So that is why sometimes those investigations takes long. I've also seen situations where Nigerian lawyers are hired to conduct this type of investigation with an American following them up to be sure that they don't sell out. things happen in Nigeria. So the US government is aware of all of that, and because it is a decision that affects the right of the US citizen petitioner, they have to be sure of their fact before a decision is taken. If you are familiar with the system here in the US, you will see that sometimes the government may take years to investigate a case before an arrest is made. One of the major differences between the US and Nigeria is that in Nigeria, they arrest you first before they start investigation. And that is why a lot of time people are not convicted, even people who are proven to have stolen billions. At the end of the day, once they are arrested first, all the accomplices, they will have destroyed all the evidence. So by the time they charge them to court, there will be no evidence to present. So that is why a lot of people get away with fraud in Nigeria. But here, it is the opposite. They can spend years investigating a case because by the time they come to the conclusion that this is fraud, they know that this is a very weighty allegation. So they don't just make it. They do their due diligence. Even when the report comes back to the embassy, they will send it to a supervisor who will review it. They have multi layers of supervision. And at the end of the day, if it is determined that yes, this is fraud, because if a divorce decree has a problem, that is something that goes to the root of the marriage. By law in the US, bigamy is an offense. Bigamy is a crime. So if a prior marriage was not properly terminated, a new marriage cannot be valid. So those are the things that it is a very weighty allegation for the consulate to say, oh, this divorce document is forged. This divorce document is fake. It is an allegation they cannot make until they have substantial evidence that it is actually fake. So that is why this investigation takes time. So I will advise you to be a little patient. And of course, if you also know that, I will also advise you to make sure that you put your house in order. But for considering how long this thing has been pending, if it is not in order, the damage may have been done already. And because they use Nigerian lawyers now, they get more information than an average American investigator will get. And you and I know that our people can sell their brother or sister for a pot of porridge called dollar. So, what's the next question? Let me see. Okay, the next question. Okay, it's part of the question. I've sent something. Okay. The next question. When COVID came, I did not get the vaccine. Now that I am in the process of getting my immigrant visa, I'm being asked to get it. Do I have to get it? Oh, yes, you have to. In fact, if you don't, I can guarantee you that they will not approve that your petition, that your application for green card. Let me tell you, when you are in Rome, you have to behave like a Roman. If you are not yet a permanent resident and you are already disregarding their rule, they are not going to give you what they want. I mean, you have your own right. You can claim that you don't like vaccine, you believe vaccine is not good for you. Yes, America is a free country. You are free to believe whatever you believe, but they are also free to keep their green card. They are not going to give it to you. So it's as simple as that. So you have to. If you don't, it will be a ground for denial. And I can assure you, with the incoming administration, they will even be more strict. They will be stricter. In fact, if you don't get it on time may be running out, because the new administration can tell you that, okay, if you refuse to get it at the time, now you are disqualified. And I tell you, you may not be able to do anything about it, because, as I said, application for green card is a discretionary application. It's not an application that is of right. The one that is of right is the is the I-130 petition that your spouse filed, and that has already been approved. So there's nothing that your spouse can do about it. Once they have approved it, you can't challenge an approved application or a petition. However, the one that they will not approve, that is the one that will give you green card, and that is discretionary, so you can't challenge it. So you better just go and do the vaccine, take the vaccine if you know you want to come to this country. The next question. Okay, is it the one in his footsteps?
Yes.
Okay. The next question. I am an Australian citizen and just married my husband, US citizen, 1 month ago in Australia. I have come to US on ESTA. Can I file AOS in the 90-day period while in US? Will they question my intent? No, you can file it. They will not question your intent. You can file adjustment of status. Not only one, the only exception for ESTA's adjustment of status is marriage to a US citizen. That is the only exception for ESTAs. Normally, if you enter the US without a visa, if you come in on ESTA with a visa waiver, you cannot change your status or you cannot adjust your status. However, one exception to that rule is somebody who is married to a US citizen. So because your spouse is a US citizen, yes, you can apply for adjustment of status and it will still be granted. This is not one of those applications that they can deny based on intent. The intent does not matter. The next question. Okay, I got the next question. If I apply for advanced parole document, is it guaranteed that I will be allowed back in the US? No, it's not guaranteed. Every case is different. Immigration is not a one-cap-fits-all. Even a permanent resident, somebody who travel out of the US, coming back to the US is not even guaranteed. So if you are using the word guaranteed, no. Every case is different. The only person who is guaranteed return to the US is somebody who is carrying the American passport. That is the only person who is guaranteed. For example, if you have a green card and you travel out of the US, meanwhile, before you travel, maybe you have been arrested for some offenses. There are some offenses that is called a moral turpitude offense. So if you attempt to re-enter the US with your green card, you will be arrested and treated as an arriving alien, and you will be placed in removal proceedings. So if a permanent resident can still be arrested at the border, how much more somebody who is carrying advanced parole? Having said that, you have to look at your peculiar situation. There are some things, the way immigration law works here in the US is very interesting because there are layers of laws. And this is one of the main reasons why it is very, very dangerous to get information through social media or get information through somebody who is not knowledgeable in immigration law. It is very dangerous. Sometimes it is better not to have information at all than to have half information. You see, immigration law, they have layers. There are some laws that will tell you that if you do A, you will get B. Meanwhile, there is another law that will tell you that getting B will get you into problem. But those who have half information, the one they will tell you is that if you do A, you get B. Meanwhile, you will not know that getting B is going to lead to problem. Let me give you an example. In the case of advanced parole, if before you are granted the advanced parole, if you have entered the US unlawfully or you overstay, and then for more than 1 year, you stay in the US in an unlawful status for more than 1 year, and then you left the US, you re-enter the US illegally, that is a permanent bar under the immigration law. It's a permanent bar. It doesn't matter even if you marry the American president, you still will not be able to enter the US. It's a permanent bar. So if you are in that situation, and maybe when you came back in, for some reason you are able to get advanced parole and then you travel, the permanent bar is still there. So when you are coming back, you are going to be denied entry. That is just one example. There are some situations where the applicant will be subject to 10-year bar. There are some situations where the applicants will be subject to 3-year bar. So all these things, they have different layers. So this is not a one-cap-fits-all question. Some people may go out on advanced parole and re-enter the US without a problem. Some people may go out with advanced parole and not be able to re-enter the US. So every case is different. So what I will advise you, whoever sent this question, if you have advanced parole, contact your attorney to say, okay, in my situation, is it safe for me to travel? Yes, it is safe. Then you go. But make sure you find out before you leave. I've seen people denied entry using advanced parole, and I've also seen people that were told that they can use it without any problem. Let me say this. The fact that you enter the US with a visiting visa and overstay, and subsequently you get advanced parole and you travel, that does not mean you are going to be denied entry. It is not that kind of disqualification that I was talking about. So there are things that trigger 3-year bar. There are things that trigger 10-year bar. And there are things that trigger permanent bar. So you have to be sure that you are not in any of those categories before you decide to travel with your advanced parole. So the next question. What happens if my job is terminated while my employment-based green card application is pending? Well, if it depends on how long your application has been pending. If your application has been pending for at least 6 months, 180 days, you can change your employer. You can look for another employer. It will not affect your green card application that is pending based on employment. That is what is called 180-day portability rule. So if you have an approved I-140 and you have a pending application for adjustment of status, and that application has been pending for more than 180 days, if you lose your employment, all you need to do is to look for a new employer. Your green card will still be approved. It is called portability rule. The next question. I entered the US illegally while I was a child. I'm now married to a US citizen. He's considering joining the army, and I've heard this can help if he files for me. True? Yes, it is true. If he's in active military duty, you can apply for parole in place. And once that is granted, you can apply for adjustment of status. Yes, it is true. The next question. How do I prove the source of funds for EB-5 investment visa? Well, this is a complicated question. It's not that it's not a one cap fits all question. Everything depends on the individual. The only thing is that you have to explain the source of your money in detail. Not only in detail, in great detail. So, where did you get the money from? How did you get it? As far as I'm concerned, start from your education. If you didn't go to school, what did you do from your childhood? How did you come about $800,000? You have to explain everything in details. And remember, you are not only going to explain the source of the fund, you are also going to explain the part of the fund. It is one thing to have the money, but how did the money get to the US? That is the part. For example, if you buy dollar from an illegal source, the petition will still be denied. I've seen a petition that was denied, even though we have filed an appeal. I can't remember whether it was an appeal or a motion to reopen, which is still pending. Partly because my client purchased the dollar from a licensed bureau de change in Nigeria. However, that bureau de change was subsequently shut down by the Nigerian government on the ground that they were operating illegal activities. Now, USCIS said that, this money came from illegal activity source. And because of that, they denied the petition. So it is one thing to prove the source of the money, but it is another thing to also prove the part of the money. The source means that in details, what did you do? How did that money get into your account? Then from your account, how did the money transfer? How did it move until it gets into the US here? So the source and the part of money of the fund. So you have to explain it in great detail. I mean, I can't tell you how you got your money. I don't know what job you are doing. So if I have to explain the source of my own money now, let's say Olu Asekun is the one filing EB5 based on investment. I will start by saying that, well, I went to this high school in Ogun State. Subsequently, I did A-levels at Oyo State College of Arts and Science, Ile-Ife. Subsequently, I went to now Olabisi Onabanjo University, or what did they call? As at that time, it was called SBS, School of Basic Studies, Igbeba. So for A-levels again, from there I went to Olabisi Onabanjo University. Subsequently, I went to Nigerian Law School. Subsequently, I went to Lagos State University. In conjunction with a couple of friends, we set up a law office, a law chambers, as we call it in Nigeria, called Ogumba Olu Asekun Okusoya & Co. in Lagos, Nigeria. We started practice. So we were into civil litigation, corporate litigation, real estate. I mean, I can go into all of that. And of course, we built client base. Subsequently, I relocated to the United States, took the bar exam, have my license both in New York and Texas, became a member of the U.S. Supreme Court, opened a law office. I also built a client base. My clients I charge for my professional services. Here are some examples of contracts with clients, and I started saving up for this amount. And at the end of the day, maybe I also invested some of my income from time to time. After over 30 years of legal practice, I was able to save maybe $1 million. Or I have this investment that is now worth $1 million. So I decided to sell my investment. Here is the proof that I sold this property that I own in Dallas. This is the closing document to show how much I sold it. So that fund was paid into my account by the title company, or maybe my investment was in Nigeria. At the end of the day, maybe I accumulated some stocks. These stocks is now worth $1 million. I instructed my, who are those people that sell stocks in Nigeria? The stockbroker. I instructed my stockbroker to sell the stock on my behalf. Here is the evidence of sale, and here is the evidence that the money was transferred to my account. And subsequently, I contacted ABC Bureau de Change. We agreed that we change the fund for me at $1,800 from their inflow, and or maybe XYZ company who is an exporter of cocoa in Nigeria, and we negotiated and agree at the rate of 1,800 to $1. So here I transfer X amount of money representing the 800,000 into their account. Here is the evidence of transfer. They also transfer $800,000 into my domiciliary account. Here is the evidence of transfer, and I subsequently transfer that money into the EB5 fund that I wanted to invest in. So you go in great details like that. So again, whoever sent this question, I don't know what to do. So I am not in a position to tell you precisely how to write your own explanation of source and part of funds. But what I can tell you is that you go in great detail. After writing the source, then you now have to write the part of the fund itself. And if you need help, you can contact our office. I believe we will be able to help you with that. We are far beyond our time, but I want to ensure that I answer all these questions. Do you know where we are right now?
The next one is, can I reapply for I-601?
Okay. Can I reapply for I-601 waiver if the first one was denied? Yes, you can do that. I've done that in the past. I've seen clients who filed the I-601 waiver themselves or even used some other lawyers. It was denied. They came here, we refiled it, and it was approved. Yes, that's something we do all the time. It can be filed. There's no limit to the number of times you can file a waiver. The next question. If my asylum case is denied, can I apply for other immigration benefit? I entered legally the US and my visa was valid as of the time I applied, but I-94 expired. Yes, if you are eligible for other benefits, you can apply. Yes, the answer is yes. The next question. I plan to move internationally in the future. How can I maintain my permanent residence? Well, there are various things you can do. You can apply for travel permit and notify immigration ahead of time how long you intend to stay outside. With travel permit, depending on how many years you apply for, you can stay outside for up to 2 years, 3 years, even up to 5 years without returning to the US, and your green card will still be valid. But you need to apply while you are physically in the US. You cannot apply after you are already outside the US. The next question. If one has NIW application approved but has not changed status, can they go ahead to renew their F1 visa to enable them travel? Can a domestic... Oh, is it part... Is it... Okay, this is a different question.
There's a number 2 and then a 3. But
I don't see the number 2. I only saw 1 and 3.
the very last one.
Oh, okay. 3 came before 2. Okay. 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 If one has NIW application approved but has not changed status, can they go ahead to renew their F1 visa to enable them travel? Yes, you can, because in actual fact, NIW is an employment-based application. So if you have not applied for green card, you have to maintain legal status. So you have to keep your F1 active, because if you become out of status, your application for green card will subsequently be denied. So not only is it advisable, but it is mandatory that you keep yourself in status. So go ahead and extend your F1 status. Yes, you have to. Otherwise, you will not be able to adjust your status in the future. So let me go to 2. If one applies for work authorization and it was approved, can it be said that the person is still in status using this work authorization approval? Well, it depends. If you apply for adjustment of status while you are legally maintaining status, Yes, it is that adjustment of status that keep you in status, not the work permit. Work permit does not keep people in status. It only authorizes you to work. Being able to work and remaining in status, they are two different things. People who are out of status can still get work permit. So work permit does not keep you in status. But the application for adjustment of status, if you have that one pending and then you apply for work permit based on that, it is that application for adjustment of status that keeps you in status, not the work permit. But the work permit authorizes you to work while you are here, whether you are in status or not, that is immaterial. Then 3, if someone has been approved for work authorization in the past, but their VAWA application is still pending for more than 2 years for determination, can this person be referred to as an illegal immigrant? Yes, I-360 VAWA application does not keep somebody in status. You have to understand all these things. There are different things here. A lot of people mix multiple things together. Like this question about work authorization. Work authorization does not keep somebody in status. VAWA application does not keep somebody in status. What keeps you in status is the I-485. If you file I-485 while you are maintaining status, or even if you are out of status, because VAWA is a family-based petition, it is one of the exceptions for people whose status expired. You will still be maintaining legal status for as long as I-485 is pending. But if what you have pending is only the VAWA application, which is I-360, that does not keep you in status. However, having said that, I have to point out that if you have a VAWA application pending and you have a prima facie determination letter, it is very, very unlikely that immigration will ever arrest or deport you, because VAWA is one of those things that they give preferential treatment to. But again, remember, we are coming into a new administration. All this may change. I'm telling you the current situation, the status quo as at today. And remember, Biden is still the president as at today. So President Trump can come in on January 20 and decide not to accord any preferential treatment to VAWA applicants. He did that before in 2017. They can still do that again. So I can't guarantee that. So VAWA does not keep you in status. What keeps you in status is the I-485. So if you have a power pending and you didn't submit I-485 with it, I will advise you, go ahead and submit it now while your VAWA is still pending. That seems to be my last question. Oh, one more.
One before number 3 with that same question.
Oh, the one I... I'm trying to see that. What's the beginning of the question? Oh, okay. Yeah, I saw it. I said, thank you. Can a domestic partnership certificate be used for immigration purpose? Well, it is not called domestic partnership certificate. My understanding of this question is that this person is talking about common law marriage. Yeah. Common law marriage can be used for immigration purpose, if that is what this question is talking about. Because, I mean, common law and domestic is the same thing. Common law simply means that you and your partner, you have been living together in the same residence for at least 6 months. You have been representing to family and friends that you are married. Oh, maybe when you want to talk about each other, you say, oh, my wife or my husband. You have represented yourself to people and they regard you as husband and wife. That marriage, that relationship under the United States law. Anyway, I take that back. Not under the United States law. Under state law. So it depends on the state where you are. Under state law, that marriage may be valid. In Texas, for example, common law relationship is a valid marriage, and they will give you a certificate for it. So if you are in a common law relationship in Texas, both you and your spouse will need to go to the county house, to the court registry, and request for a certificate of common law marriage. And with that certificate, yes, you can apply for immigration benefit. We do that all the time, and it will still be approved. So that seems to be the last question for the day. We are well beyond our time, but I intentionally decided to wait this long because we want to give people the opportunity to ask questions and answers before we get into the new administration. Did you say I have one more?
Yeah, someone is saying that they sent another one to the phone. Let me just quickly check.
Okay, I send a question on the phone, please. Okay. If you see it, I can read it directly from there. In the meantime, for next week, before we wait for Donald Trump's incoming administration, for next week, we are going to be discussing international entrepreneur rule. International entrepreneur rule. This is a topic that I've been receiving questions on lately, and I decided that I will handle it. International entrepreneur rule. So remember to join next week. International entrepreneur rule. That will be the topic next week. Okay, thank you. So the last question that we have: if someone committed a theft-related crime when he was a teenager before the Riley Act was passed, but just applied for immigration status, could they be detained or deported under the new law? Well, the truth of the matter is that it depends on the gravity of the offense, and it also depends on what relief that the person is applying for. If, for example, the person is married to a U.S. citizen, generally, an applicant who is married to a U.S. citizen may be eligible for a waiver, even waiver of criminal ground of inadmissibility. So it depends on the gravity. For as long as it is not aggravated felony, if it is just a theft offense, yes, you can still be able to adjust, but you may need to apply for a waiver. So it doesn't matter the new act or not. You will still be able to get your green card, but you may need a waiver. But if this is employment-based, with the new administration, it may be an issue because I remember during, I think it was during the last Trump administration that they amended Form I-485 to include questions about criminal activities and all of that. But generally, if this person, please take, if this person is seeking adjustment of status based on a marriage to a U.S. citizen, the probability that you will get a waiver approved, I will rank it about 95% based on this fact. So, in the absence of any other question, and considering the fact that we have spent a lot of time today, I hope to see you guys next week. Follow up or a different question? Why are they sending it on that one and not? Okay, let me quickly read it.
They sent it just not too long ago, like 2 minutes ago.
Okay. Maybe what I now consider the last question. If you are a green card and you apply for children, and in the process you get your citizenship, and then they were scheduled and went for the interview, and they said every document is okay, but their status changed and were not given the F-22 visa in this case, what do you do? Thank you. Well, what this person didn't say is the category, because I don't know how long how old the children are. Because the truth of the matter is that if your children, if they are over 20, well, it depends on the category, because in some cases, I know that there are situations where we have to avoid notifying the embassy that the applicant has become a US citizen, because it notifying them will delay the case. And again, there are some situations where you may have to refile the I-130 petition. There are situations where you may have to refile. For example, let me tell you one of the major differences between a US citizen petitioning for a child and a permanent resident petitioning for a child. If, for example, a permanent resident petition for his child, his spouse, let's say a permanent resident who lives here in the US, petition for his wife or husband who lives outside the US, and they have a child, you see, that petition will cover that child. That petition for the spouse will cover the child. So when they go to the embassy, both of them will be given immigrant visa. However, that is not the case for a US citizen. So if a US citizen is the one petitioning for the wife and they have a child who is a minor, the US citizen, the moment you become a US citizen, you will need to submit a separate I-130 petition for that child. The child will not be covered with the petition that you file for your spouse. Remember, in the case of a permanent resident, the child will be covered. But in the case of a US citizen, the child will not be covered. So that may be what is happening in this case. If that is the case, you will have to file a brand new I-130 petition for your child if you are already a US citizen. The reason, let me tell you the reason why there is that distinction. If you are a permanent resident and you file a petition for your spouse, if that petition is approved, both your spouse and your child will get a permanent resident status. But if you are a US citizen and you petition for your spouse and your minor child, if those petitions are approved, your spouse will get a permanent resident status, but your child is going to get US citizenship. So your spouse is not going to be given green card, it's going to be given citizenship. So that is why those things don't go together. So that may be what is happening in your case. So once you become a US citizen, you may need to file a separate petition on behalf of your child, because your child will no longer be covered by the petition that you file for your spouse. I hope that my explanation is very clear. Okay. Oh, okay. The two that came here.
One here and then two.
Okay, I have one here, Dr. Asekun. Can NIW be approved when out of status in the US? Yes, NIW can be approved. What may not be approved is the green card. NIW is different from green card. So NIW is the petition. Yes, if you are eligible, the petition can be approved. However, if you are out of status, the application for permanent residence can still be denied, even though you are in status. Okay, the last one, I understand approval of NIW is a separate issue from conversation of status, but is one's current considered in the evaluation and possible approval of NIW? No, legal status is not considered. It's the eligibility for the NIW that is considered. So it is not the legal status. They evaluate whether you are eligible for NIW. That is what is considered. But the approval of the NIW itself has nothing to do with the approval of the green card.
There's one more after that.
Which the
The bottom one.
the last one? Okay. Happy New Year, Dr. Asekun. Please, sir, if I apply for H1B outside of the United States and it doesn't get picked in the lottery, can the person apply for school as a student? I hope my application for H1B will not be taken as intention to stay. No, both H1B and student status, they are both non-immigrant status. The only application that will affect non-immigrant status is an immigrant status. Let's say you've applied for NIW, for example, and then got denied. That one can affect your F1 status because NIW is an immigrant application. The form used for NIW is Form I-140, Immigrant Petition for Alien Workers. So that's an immigrant intent. So once you show an immigrant intent, you are no longer, there is a presumption that you will not be returning to your home country when you apply for a non-immigrant visa after that. But in the case of H1B, H1B is a non-immigrant visa, so it does not show immigrant intent. But of course, remember, F1, H1B, visiting, all these things are discretionary type of application. So even though it does not show immigrant intent, they can still deny it on the basis of discretion, as nothing discretionary is guaranteed. So I hope you guys will join us next week. Like I said, next week, by God's grace, we'll be discussing international entrepreneur rule. That will be the last topic we will discuss before the new administration. So we hope and pray that the new administration will be beneficial to all of us. We will try our best to be proactive in providing information as soon as the new administration is sworn in. Right now, there has been so many speculation of so many things that they plan to do on day one. But again, this is speculation, so I'm not going to rely on any speculation. But by God's grace, as soon as the government is sworn in, whatever new information that comes up, we will be very, very proactive in providing information and what people can do to keep themselves safe and keep themselves in status and get themselves legal status. By God's grace, we will do our best in providing this information. So I want to thank you for listening to our podcast today, and I want to implore you that the only thing that you can do to show appreciation for this gesture is to invite your family and friends. Of what purpose will it be if you are the only one benefiting from this wealth of information? We are not charging for this. We do it regularly free of charge, and we answer every question in great detail. It is not because we just want to look for clients or anything. No, it is because we see people making avoidable mistakes, avoidable errors from time to time, and we believe that even the Bible says our people perish for lack of knowledge. We see that people make simple, avoidable mistakes, and that is why we decided to go live and provide adequate information. We also see that there are so many misleading information online. Please don't listen to unqualified people. There are some people who are just looking for money. In fact, recently, somebody brought to my attention an organization here in Dallas that has a website that was charging people up to $20,000 to help them process NIW. Please, all these things are scams. This person is not even a lawyer and probably does not even understand the details of NIW. And yet, there were victims. In fact, the person who brought it to my attention has already paid this organization more than $10,000. There are so many scams out there. Please look for credible information. I know that sometimes it is difficult to know who is credible and who is not credible. But the starting point is this person licensed? I mean, you can know if somebody is not licensed. How would they even be telling you that they are providing you with authoritative information? So people who are not licensed, be careful. There are so many viral YouTube messages, TikTok messages, Facebook messages that people send to me from time to time asking me to verify it. There was a time somebody, a popular blogger, a popular Nigerian blogger, posted something on her post that, oh, immigration, US is giving a green card to people, US is doing this, all kinds of fraud. Please avoid all this scam. People are just looking for money and they will do anything to get money. Please avoid them. We hope to see you again next week. Thank you for listening. And for next week, we'll be discussing international entrepreneur rule.